gentlemen, dear ambassadors and the representatives of the diplomatic delegates from Geneva, the consul generals from Lyon, the professors from the Lyon Academy, ladies and gentlemen, representing the René de Falco and Judge Donnedieu de Vabres families, the manager of the US Center. We're so happy to welcome so many people here to this session. You've come here to participate to a colloquium we see as being crucial. We're talking about the news of the Nuremberg trial 75 years later. It's important for us to remind us of the link that is between us and them. The 5th of February 1926, 46, he mentioned the issue here, and he mentioned the teletext that was sent by Klaus Radu, who ordered this roundup here as being against humanity here, crime against humanity. So several years later and several decades afterwards, this led the family of the Judge Robert Falco in 2011, and then the family of the Judge Henri Judge Donnedieu de Vabres in 2019, and finally the General Prosecutor Donnedieu de Vabres in 2021 to give their private archives to the Maison des US Center. So this album, which is called the Nuremberg Trial, given to the Donnedieu Judge, arrived here at this center. Thanks to the support from the American Consulate in Lyon, we are able to have it restored, able to digitalize the pictures, and even produce a couple of facsimile. You'll see this album a bit later on, which will be presented to us by Stephanie Brossard, who's head of research, archiving and documentation here at the ISU Center. Throughout this afternoon, we'll have historians, sociologists, and jurists will talk about certain facts that aren't necessarily well known in terms of trials. The position of women and the magistrates during the Nuremberg trial will be in particular highlighted by Diane Marie Aman and the racial issue. In this during this trial will be mentioned by Guillaume Morales. We'll talk about the role of the French delegation that will be presented by the jurist and his own Jean-Paul Jean, Michel Mathieu and Mathias Gimili. We'll have a discussion in terms of the International Criminal Tribunal that will open up here with Philippe Sens and Xavier Jean Quetin. Thank you all for being with us this afternoon. I'd like to thank you all for being present. Good afternoon. So the mic seems to be working. Hello. Last week, I had the opportunity to travel to the beautiful Lake Annecy, and I visited the Packard Foundry. It's one of France's oldest bell makers. They were completing an amazing project for an American university. And after this visit of the foundry, I talked with the head of the Packard foundry, Philippe Packard. He's the seventh, represents the seventh generation of his family to Capelle. He told me the story is his father shortly after the Second World War. I mean, Philippe's grandfather woke his father up in the middle of the night, extremely excited. Packard bells had been selected by the US government to make over 50 replicas of the Liberty Bell for all the 50 states in the US. His Liberty Bills rang during the independence war in the US. His grandfather was extremely excited, and his grandfather was so excited that they opened a bottle of champagne, even though it was 1 a.m. in the morning. And this is a story he'll remember for the rest of his life. And for me, it's exactly the same here. I will remember the beauty and the craftsmanship that goes into making the bells. Particularly more is the story of a young boy and his father. The same goes here when we're talking about stories, personal stories here. A little over a year ago, I first met with Dominique Verdot, director of the Maison, and he talked about a project. And I talked about an American photographer, Charles Alexander, took pictures during the Nuremberg trial. And I was really moved here, and we started this project, and today we will be showing it to you. And later on, but I mean today we'll be listening to the work that has been accomplished by the professor Diane Mary Ayman. She's professor of law in the University of Georgia. She'll talk about the personal story, not well known, of women who worked during the Nuremberg trial. And with these stories, we can help other people to remember the work accomplished and the relevance of human rights today. Yesterday, we were talking with the students at the University of Lyon 2, and one of the students at the University of Lyon asked us a question. They said the pictures are in black and white. The story is far away from us. Why is it so important for us? And which is why we are clearly doing what we are doing today, to help the next generations remember these stories and give the same importance to human rights, crime against humanity, and genocide, and really make sure we can improve the world in general. Hello everybody. I think we had 5 minutes to introduce things here, so I've got 20 seconds left here. Now I'm speaking under the authority of my grandfather, as you can see in the middle, which is a bit intimidating. I can actually see that he's no longer on the picture. I'm the grandson of Henri de Vabres. I'm not the only grandchild, because there are 10 of us here. We've even got third generation grandchildren who've come to participate in this session. This just shows great-great-grandchildren. A couple of just shows the relevance and the loyalty we've got to the souvenir of our grandparents or great-grandparents. We're here at this colloquium because it's the opportunity to meet descendants of Judge Donnedieu. This is the first time I'll be meeting them, and it's crucial. It's also the opportunity to initiate an open and promising discussion with Philippe, who we heard just before lunch, and we'll be pursuing the discussions in the coming weeks, months and years, because it's a vast subject here. The album, the restoring of this album, of the 121 pictures of the Nuremberg trial, which we gave in 2019 to the Maison Center, clearly supports us in the idea that it was the right thing to do here. And this is what we were able to find in our family archive. We'd like to thank the Consulate of the United States in Lyon for their significant contribution to restoring this album. And the album we'll be seeing today isn't quite the same album as the one I discovered in the basement 3 years ago, and its future is guaranteed for them. Thanks to you. The souvenir of our grandfather is precious, and we were all impacted by an article that was published in a big national newspaper in France, which clearly was criticizing its memory. We tried to respond here, even though we used lawyers here. Now we don't want to go before the courts, but we want to explain that we disagree with what was mentioned in this feature and this article of the newspaper here. And they had a question, an elder man, a member of our family, who's over 80 years old. We're not quite sure what was said, but we know what was actually mentioned in this newspaper article. But the honor here, the Maison des US Center is displaying today, and especially my situation as a grandson of de Vabres. That means that I'm not totally unbiased here. So obviously we have to consider the historians here, and it's the historians we will be listening to now here. And we would like to particularly thank the remarkable job that has been done in terms of work. Laurence and Matthias, their work was published, the Judge of Judge Donnedieu de Vabres at the International Military Tribunal here, and that was published. And finally, because we haven't got much time left, I'd like to consider the tribute that was made by in fact, the dean here, he said he was one of the judges of Nuremberg, and we can see the dignity that was given to law here and the people, and he was totally unbiased. He judged without the slightest weakness of the people for the crimes they committed themselves. He couldn't tolerate or would punish individuals just because they belonged to a group that was guilty, whereas their personal guilt had not necessarily been proven. I'm going to stand for to Mathilde Philippe, who will be the moderator for our session now. Hello everybody, I'm going to take a seat here. And I'd like to start off by thanking the organizers of this colloquium here. I'm going to ask the two people to join me, Philippe Sanz and Mr. Kita. Unfortunately, I have to sit here. So we're talking about an important subject to get this session going. This is a question I'm asking both of you. Would you say is international justice possible? Normally, I need to introduce you. We heard you this morning, Philippe Sanz, but I think you both were introduced this morning. Just a reminder that both of you are lawyers. Both of you plead before the International Criminal Court. Philippe Sanz is written many books, in particular returned from Nuremberg, and Mr. Keita, you joined the International Criminal Court in January 2017 as the main counsellor for the events. You were the founding member of the International Centre in Africa for French-speaking lawyers. You were the experienced mediator, and you were a judge at the International Organization of the Francophonie here. So you can see how rich our debate will be. So I think, Mr. Keita, you can answer the first question, and then afterwards Mr. Sanz. So the question is, do you really consider that international justice is possible? Thank you very much for introducing me, and I'd like to thank you all for being present. I felt quite emotional when I visited the museum this morning, and in particular as it concerns children here, we tend to see opinions become extremely banal and words become extremely banal. And very extreme words are just become mainstream. It's reassuring to see that there are many of you present in the audience here. We've got people here that are the guardians of our shared and common heritage, us as mankind. To answer your question, or humankind, this is the status of Rome here. Oh yes, an international justice is possible and it actually exists. It's not easy, and it was created nearly 20 years ago. It's called the International Crime Court, which I've been with on a regular basis for 15 years. It's the first that meets the principle of fundamental law, which we all as jurists have wanted to create. So no crime, no justice is possible without law. Now, before we judge or assess or evaluate a person, we have to consider law. Now, this court, this tribunal, has got an ancestor, and that ancestor, and those are the Tokyo jurisdictions and the Nuremberg jurisdictions. I would say this ancestor was considered at the time, and even nowadays, a bit like the justice as established by the winners here. And the people would say, you committed the same crimes as we did here, and you weren't even allowed to allude to that during the Nuremberg trial. Now, instead of talking about the justice of the winners, it's the justice organized by the winners. Let's put it that way. We can imagine the Allies and the defeat of the Allies, and if the Nazis had decided to judge the General de Gaulle, probably they would have found him guilty. Now, Nuremberg, without being perfect, be it for the prosecutors or for the advocates, at least within a year it had the merit of establishing the foundation of the International Criminal Court, and after 1 year the decisions were made. Now, obviously, we can't be proud in terms of the reviews. The procedures are long. If we consider the International Court of Justice, the procedures aren't necessarily understood by the greatest number. We say that the court is a political court, but at least it's got the merit of actually existing. It's a necessary evil. It's what we call judicial dissuasion. Since this court, International Court of Justice, exists, the criminal court exists, when the crowds are walking towards the powers, the people in power, at least the people in power don't shoot at the crowds here. It doesn't mean that the International Court cannot be created or cannot be criticized, but it's a great initiative. Before this initiative, the initiatives had been those of the United Nations and a resolution creating following the massacres of the ex-Yugoslavia crimes here. After the genocide in Rwanda, we had a resolution by the United Nations in 1994 to create an international court. That's what we call a reactive justice. So it's a disaster, and we want to repair by establishing law. So no crime can exist, no punishment can exist without law. And finally, it's the International Criminal Court that will respect this great principle. We get together, the states on a voluntary basis accept, based on a treaty and an agreement, the existence of this court. And it's a permanent court. All the others are ad hoc courts. The special court for Lebanon will be closing down in the coming months because there aren't the necessary means and resources. Now, to get together and to be stronger. That's the greatest act of sovereignty as far as the states are concerned. The fact that they are willing to be stronger together by abandoning part of their sovereignty to decide that at the international level that the victims will have a place. The International Court has enabled this for the very first time, to decide that these crimes, there's no possible prescription here. That's the International Court to actually decide that regardless of the quality of officials, and that's Article 27, by the way, whatever who you are, King, Queen, Prime Minister, President, your immunity cannot be opposed to this institution. They have actually prosecuted two heads of state, Alain Barbashir, that led to us being obviously being frowned upon by the African countries, but nobody can ignore the very existence of the International Court of Justice. We are criticized for just being a colonial tribunal because we're just pursuing the head of states. Now, obviously, if it were so, I mean, I'm proud of my African origins here and even from part of France, but I can say it's totally unjust to say that the International Criminal Court is criticized of being a colonial court. It started in 2009. They decided to prosecute really a head of state who was still in office here. Now they're saying, yes, but you ratified it, you actually agreed, didn't you here? And they all started to become afraid here. And then the propaganda was created against the court, the international courts. I mean, it's okay when you're talking about warlords and prosecuting them, but how about prosecuting heads of state still in office? That wasn't seen as being as positive anymore. So the international court is there, justice exists. You cannot develop as a state in a situation of civil war. And if we need to put in place peace through justice, the International Criminal Court is there, and they can install peace and enable development. Those who are elected officials, they're there to protect us. That's their first duty. When you've got a crime against humanity, I mean, the last century, we were walking on the moon here. Here we're starting to walk here the wrong way up here. We're talking about men, women that are raped. Obviously, we cannot have a situation where people are not punished. And personally, I refused the stamp to the International Court, Criminal Court. Why? Because to actually fight against people who are not brought before. But I'm there as an advocate. I'm not a prosecutor. I'm fighting again for justice and not. And justice means we have to be fair and equitable here. And the defense needs to exist. And the International Criminal Court hasn't yet been able to get up to that particular level where we actually protect a certain number of things. Yes, I just wanted to, just one last minute to say, we can criticize a lot of things about this International Criminal Court, that they're just prosecuting part of the planet. No, we just prosecute individuals, not states. We can criticize it, that it's got a big budget, but if you consider its ambition, this budget is nothing. It's 149 million euros, which is nothing when you think about it. When we criticize it, that it gets involved in things that it isn't considered. Why aren't they prosecuting in Israel or elsewhere? But they do. Now, for some of its members, they are punished by Americans, by the Americans, for example. So from Nuremberg to The Hague, you will see at Nuremberg the Americans were ahead. They were ahead in terms of the prosecution. In terms of the analysis, in fact, this morning I found out that after Nuremberg, there were other American trials that were organized by the Americans targeting certain doctors. And today the International Criminal Court hasn't succeeded in bringing together the great powers. If we consider that those who've got a right for veto, it's only France and England who have ratified it. The Americans haven't ratified it. China hasn't ratified it. Russia hasn't ratified it. India, Pakistan haven't. Israel. And it's your commitment, it's your engagement, it's your support that will maybe one day make sure that these countries consider that they should belong to the process. We need to believe in justice, believe in international justice, and even though it's not perfect, it's at least got the merit of existing. Thank you, Nuremberg, for having opened up this possible approach, even though it's far from being a perfect approach, and that we're pursuing this nowadays, even though it's not perfect, but at least it's got the merit of existing. No sentence, no crime without law, and nobody ignores the very existence of the International Criminal Court, and they consider genocide, crime against humanity, crime against aggression, and war crimes. And that's since September 2002. Before this did not exist, because now we know that law exists, and if you infringe that law, you face your responsibilities. Thank you very much. Thank you very much. There was a lot in your presentation. You talked about criticizing the international military tribunal. Here we're talking about the justice of the winners, because usually the justice of winners is to actually shoot those who have been judged, whereas that's what we taught at the Faculty of Law, and then afterwards you showed that the International Criminal Court has shown that it is possible to have an international justice, even though it is not perfect. What do you think about it? What's in international justice, is it possible? Well, yes. Is it the case nowadays? No, not really. We fully recognize that international justice, and the word in English is the long game, basically. It actually happened in 1945, thanks to those who negotiated and adopted this particular status with the prosecutors, the judges. I'd like to pay tribute to all the judges, including the Judge Donnedieu de Vabres, that did an amazing job. But in a very specific situation, what they did, they opened up a door here. And when I'm trying to see where this door can lead us, I always remember two anecdotes, two stories. The first one was about 25 years ago. I was a young scientist, as a young researcher at the University of Cambridge, at the St. Catherine's College, and there was a professor there. I was very close to it, John Baker, a professor of history of British law. Every 6 or 7 weeks he would invite me to have lunch to find out what I was actually working on, and I would tell him such and such a thing, X, Y, and Z. Then he would think, and he said, "Oh yes, Philippe, oh yes." And we had that problem in British law. We had it in the year 1472. And it took 275 years to sort out that issue. And that is to say, you can't create an international law in 1945. The principles, the rules, the processes. Now imagine that 75 years later, everything will not be sorted out. It's one step forward, a step to the left, to the right, another step backwards, then 2 steps forwards. It's the long play, and it's going to take hundreds of years to really imagine a true international justice here that would apply to everybody. It's only in 1947 that for the very first time in British law that we were allowed to intend an action against the Queen. So very, very recent. Second story.
When I was in Washington, D.C., I was doing a conference at George Washington University with Thomas Bogentag, a leading American judge, and who had been at the International Criminal Court for 9 years. At the age of 10, he had been at Auschwitz, and he was amongst a group that was subjected to Joseph Mengere's treatment. And so we were doing a conference on the future of international justice. And 2 weeks later, I was preparing to go to the International Court to plead in the case for the Rohingya and Gambia, the Rohingya against Myanmar. And at one point, Thomas Bergenthal turned to me and he said, "Can you imagine, Philippe, that in 1944, if we'd had a situation where there was a convention against genocide and a small country far away wants to take action against Germany?" Well, that was unthinkable. So can you imagine? Think of that difference in 75 years. So it's not perfect, you're right, but it's remarkable nonetheless. And something else you said that really touches me. It's clear that all of what was done at Nuremberg has served international justice. We know there are problems, and we know that there also new crimes have been added to the list. We know that some have been applied retroactively, but we also know that there was only one type of defendant during the Nuremberg, so there were only the Germans, in fact, and Germans and some Austrians. And so this created lopsided justice. So I'm not sure I can say that in French, but so there was no balance here. And so what I fear is that, in spite of what you said, that we still have a very big problem in The Hague. If you go to their website and you look at the identity of the 46 individuals who have been indicted before the International Criminal Court, they are all black, they are all African, and yet they do not have the monopoly on international crimes, and this is deeply troubling. For example, in Afghanistan, since 2002, there have been many allegations made on all sides, in fact, between the Taliban, the government of Afghanistan, the United States, the British. But nothing has happened. Why not? Well, we know why not. Because of power. Because power is everything. And so, yes, the door has been opened, and it's opening a bit wider. But, in my opinion, and it seems like it's going to be a very long journey. So, Mr. Keita, yes, I would like to say a few words. So I'm going to have to, I'm a defense attorney, so I'm going to defend the International Criminal Courts. I mean, you know how cases are brought before the court. Well, there can be at the initiative of a prosecutor or a state that might refer a case, and then we investigate. And during that investigation, if we have reasons to believe that certain things have been committed by a person, then it goes to a preliminary chamber who must issue and validate a warrant for their arrest. And then, if we look at some places on the planet, and we might say it's been devastated and we don't know who the perpetrators are, well, there is nonetheless the Security Council, which acts as the police of the world, and this is the Chapter, Article 7 of the United Nations, United States, France, the UK, and with the approval of the international community, well, might be asked to intervene, such as what happened in Libya. So I make that aside to say that if we look at today's picture, it's true that all the people currently indicted are Africans. For me, as an African, we have to arrive at a situation in which we remove impunity. But we have to do this everywhere, it's true. And so I'm certainly not blaming the fact that right now it's all Africans. So my question is, are there victims in Africa? Yes, there are. And so then we must abide by our word. And it's not just because there are crimes elsewhere that we must not pursue the crimes brought to us. And the African states are amongst the first to bring cases before us. When in 2008 there was the anniversaries established, and I was asked, when it's Europeans that preside the court, things happen a certain way. And I have said to them that 3/4 of the cases brought before the court were referred to us by African states themselves. In Uganda, the Congo, the Central Africa, even Mali, came to The Hague, Ivory Coast as well. And when Ouattara came to power, he referred a case to us, and then the Ivory Coast joined the Rome Treaty. And Gbagbo, I attended the first hearing of President Gbagbo. He had referred cases to us from 2003 because we have accepted the statutes of Rome. And so I can't sit here and let you say that there are only Africans before the courts, but we, our Africans themselves, have referred cases to the court. And so, once again, elected officials, their main duty is to protect us. And so I'm very proud that it is Africans who have referred cases to our court. And so this should help us to institute order on our continent, because that is what we need. So, I'm going to... So, this might be a bit provocative, but... well, what do you say to that, if we're going to be provocative here? Well, now it's Mr. Sands' turn. Well, yes, the court has its competence, but, it's, okay, this was my response. Okay, yes, but I'm not entirely satisfied with this answer. If we look at Afghanistan, well, I can tell you something about Afghanistan. I was one of the first prosecutors, and I was asking, well, why is nothing being done on Afghanistan? And I was told, you know full well why we're not doing anything. We know the reality. And so we have to be aware of this and speak openly about it. So little by little, we have the example of Afghanistan, and what about the situation in Iraq involving the British? There was no trial there. And those have been set aside. Those cases have been set aside. So this bothers me. I find I see this lopsided justice with great despair. And we're still doing the same thing as what we saw 75 years ago. Law is like a spider's web. And yes, who are the spiders? Well, they're catching the small ones, but the big ones are getting away. So I think that's the reality of our current world. I thought you were going to quote Victor Hugo to do with the powerful and the miserable. Well, I'll give you a proverb from Mongba, from Mali. The day might be far away, but it doesn't mean it's not coming. So we have to be optimistic. We have to believe in what we're doing. So just take it easy, step by step. We'll get there. Okay, yes, there's Afghanistan. And some members, the prosecutor has just stepped down, was prohibited from traveling. A judge at our criminal court who was opening investigations at Afghanistan was subjected to mistreatment by the Americans, prevented from traveling. And so I've, on the Afghanistan situation, there was a lot of hostility toward our attempts at investigations. And other situations that haven't yet come before the court, but where we expect to be investigating in Colombia, in Georgia, the Republic of Georgia, in Afghanistan. We're trying. It's not just Africa. And in Palestine, the case has been opened, but the big powers are protecting their allies. And one thing I would like to criticize my court about is that we need to be looking at ourselves, what about being the gendarme of the world, being the police of the world? We have to play that role. This has worked in Sudan. So I found it scandalous that we could see those massacres going on in Syria because one of the great countries vetoed any action. And so that is a political action that paralyzes our court. And so I really wonder why, 75 years after Nuremberg, we still have these vetoes. In the name of what? To protect certain powers? You yourselves should be denouncing this veto rather than saying it's the court but that's in the Rome statutes. It's imperfect, but that veto power exists. And in Article 16, we're trying to give peace a chance. The Article 16 means that any party may say that reconciliation is possible, and the Security Council can suspend investigations for a year, which can be renewed. So that is a way, for example, that Kenya opted for, where some high members were being investigated, and it gave and then the Kenyan population became very anti-court and driven by their leaders, and then the opponents gathered together and took over Kenya, but they continued to cooperate. They came to the court, they came to the hearings, and they continued with their ordinary activities. And then, as you know, the charges were dropped because when you're in power, the penal court has no police or army. It has no law enforcement teams. So, you know, a country might just be pretending to cooperate. And so the prosecutor at the time had preferred to drop the charges rather than to arrive at an acquittal, because those indicted little by, kept moving around, changing their identities. And so, when witnesses were called, it wasn't possible. And in the papers, we were hearing that so-and-so would be testifying against our head of state. Well, of course, the witnesses would not go if they had been identified. I've been identified, even though I tried to hide my identity, and so they were afraid. And so that is a weakness of the court. But that's a reality, but you can't blame the court for that. We don't have the resources. We don't have an army. And, we all together created this court, and we fund it. You all fund it. But at the same time, it's best to be a part of this Statute of Rome, be part of this court, than rather stand outside it and criticize it. Well, I'd like to change the tack of the conversation a bit. So here we're talking about the international level, but that's a rather small portion of the work. That's not where things really happen. Where they really happen is domestically. And so this type of conference, we tend to forget that, looking at what's happening within each country, or things that might not come into the newspapers, or that isn't in different languages. For me, this is where we see some things going on. It's not necessarily at the international level. Let me give you an example. Which country is pursuing the leaders of Daesh, of the ISIS? There are various trials underway that are very interested on crimes of genocide by rape of women. No one's talking about that. No one is talking about the consequences of the international travel of great leaders under the principle of international competency. What happened when the Americans began in 2003 or 2004 of being accused of waterboarding? Nothing happened at the international level, but at the national level. Some prosecutors began conducting investigations, and because of these, some leaders of the country were unable to travel. Mr. Rumsfeld, for example, he no longer left the United States. Mr. Bush, who was supposed to go to Canada and Switzerland, canceled those trips because two prosecutors indicated that it would be possible that they could be questioned on the point. Then, so if we look back to Nuremberg, the most important of the trials that followed was not an international trial. It was at the national level. And that was against Senator Pinochet. Why? Because like at Nuremberg, this was revolutionary. For the very first time in history, a national court in the UK indicated that in the context of an international crime against humanity, a former head of state no longer has immunity. That was extraordinary. And the outcome of that, the impact of that was enormous, because this hindered the ability to travel of all those called for questioning. So if we ask that question, is international justice possible? I don't think we should be focusing only on the word international. Yes, we also, at the International Court, recognizes complementarity. But it's really at the national level that so much can change. And I think in the coming years, that is where we need to be putting our focus. But is universal justice possible? And then in that sense, there could be complementarity between a national or state-driven justice or international justice. Well, when we're talking about international justice, we're also talking about crimes that are also being raised at the national court level. And we forget sometimes that once you have signed the Rome Convention, it does imply changing domestic law. And they must be transposed. All of the crimes of the international law have been transposed to national law. And the UK did this to include crimes against humanity. We had a genocide from the 1948 Convention. And so there's a lot of complexity at play here. But this, I think, is why we shouldn't just be looking at what's going on at the international level. Do you agree with that then, Mr. Keita? I fully agree with Mr. Sands. I would like to remind you that the International Criminal Court in the Rome Statutes speaks of complementarity. And so the European jurisdictions, before seizing them, so you have to go via the national courts and appeals courts, etc. And so that lies with the states. And so when we say that the International Court, for what it's doing in relation to the African states, I mean, the African states should be thanking the International Court, because it means that there was no complementarity, but it is up to the states to investigate. But if they can't, or if they don't want to, or if they are pretending to do this, to try to protect certain ministers, for example, it's only in those cases they can take over and decide to conduct its own investigations. So we talk about international criminal justice, but it provides for the primacy of the domestic court system. What's unfortunate is that some states that might be concerned by the nature of these crimes are developing countries and don't have the means to offer a justice that is independent, devoid of corruption, that has modern mechanisms for the organization of the judicial system. They don't have the means. And so this is why we speak of positive complementarity. And what we mean by that is that we must help the countries that need it to train judicial officers. And so ideally, we would have no work at the International Court because the states would have their resources to pursue investigations and trials. But we are far from that situation. And so the international, yes, it must be there, but we must begin always at the national level. And that's all the more reason why the African countries cannot be blamed. All right, so we've reached some form of agreement here, so that's already quite an achievement. So let's just take one or two questions. I know we're running a bit behind schedule, but do we have one or two questions from the audience? As we know, the first question is always the most difficult. I mean, because I have plenty of questions, but this is your chance in the audience. All right, well, I'm going to go with my first question then. All right. Okay, so let's talk about how the international justice can be improved. We've talked about giving states the resources. Do you have any other suggestions for making international justice possible? Of course, with complementarity. Well, I have some suggestions, in fact. I have made these public statements, in fact. If it's the first court, is giving a voice to the victims, we must listen. If there's acquittal, and many feel that they are victims in a second time. This happened at the Bemba trial, at the Gbagbo trial as well, who were acquitted. But this is law, and the International Criminal Court is not a human rights court. Then we must seek the responsibility elsewhere. This is a prosecutor who didn't do his job. The defense attorneys were excellent, but the judges have decided. And so, we don't want to see people feeling victimized a second time. So we can't rely on this mechanism of the International Court alone.
To be able to pay the victims back, the first responsibility in the case of victims is the state, because the state failed by definition. So it's up to the state to immediately indemnize the victims, even though they may be pursued in front of the courts. If the state can't, the victims need to receive compensation. Now, it's the Security Council who's supposed to be there as the kind of world police force. So it's the United States, which means the international community, all of us collectively, needs to repair, needs to compensate. It's up to the international community, then afterwards to have a recourse when people are convinced or have been condemned here beyond any doubt. That would avoid the victims to be victims a second time. Let's face it, 3/4 of the people who are being actually put before the courts are considered as being indigent here. Thomas de Banga, the first person who was brought before the courts, he was condemned, but he's got assets. Well, what's he going to do? Is he going to say sorry to the victims? No, we need him to repair. This is a concrete proposal here, compensation. Second proposal is the duration of the procedures here. The right to the law of Rome was negotiated within a treaty. The community, the judges, the diplomats, the magistrates, they each tried to impose a law of origin. It led to a mixed law with an Anglo-Saxon approach here, with the participation of the victims. So it's a whole mix here, but this mix isn't the best possible outcome as such, because there's no initial truth, let's face it. The prosecutor is there to investigate. Here, I'm a defense attorney. Do you think I'm going to really... No, you can forget about it. So for me, as a defense attorney, I'm going to go locally to investigate, even though it may be 3 years later. And the victims as well, they are there to have truth come along. So we've got 3 truths that come along and that are put forward here. And we've got procedures and court cases that last 8 or 9 years. And then we're forgetting a principle, a fundamental principle. And that's the freedom is the rule. And its imprisonment should be the exception. I mean, if it were an international court, a criminal court, where national here, they would be condemned. We need to reduce the time and the duration. We need to change the process of procedures and to really make sure that we have a kind of general attorney who deals with it, and then afterwards they investigate, and then afterwards we will have the defense counsel, prosecutor and the victims. They will have time to carry out their own investigations, and it won't last 10 years. It will be faster, not as expensive, and we'll have something much more satisfactory here. Those are my proposals. Thank you very much for your proposals. This will be, we started with you and we'll finish with you. That's great, but I've got the impression that we will be fiddling while Rome burns. I think there are issues that are much bigger out there. There's a total lack of a political will. In 1945 there was the definite political will. In the 1990s there was a political will as well. It was there. Currently there's no political will out there, and I think the most important, for the moment at least, is to advocate the idea of international justice, because it's not a given. We can see, and we were talking about this over lunch, we see what's going on in certain countries at the moment. At the moment, you can't go anywhere to talk about the Uyghur issue. Once a week, I receive a request. What can we do about the Uyghurs? Is there a tribunal? Is there a court? And the answer is no. The United Nations, they haven't even had access to the camps, the Uyghur camps. So if we're talking about international law or justice, for me, the focus shouldn't so much be on the procedures of certain instances and bodies at national or international level. The idea would be to cover a political will on the basis that no individual and no state is allowed to act in a certain way. But it's a great concern for me at the moment. For 4 or 5 years now, we've got this project pertaining to a project for preventing and punishing crime against humanity as a parallel convention agreement, like in 1945 regarding the genocide. This isn't going anywhere. It's been blocked. It's a deadlock at the UN level. Because it's amazing, those states, those countries that created the actual system in 1945, those countries, those states have lost the will, the determination to pursue their own project. So for me, the focus should be not at legal level, but at political level. We need to encourage those countries who did that much in 1945 and also in the 1990s to get around the table again, and to encourage those countries that didn't participate at the time but should be around the table now, including China, Russia, and many other countries. And we need them to recognize that it's not acceptable to act in that way between 1933 and 1945, to act in that way, and it's not acceptable today. And I agree with you, there is a big issue if we consider the Security Council of the United Nations. It's totally ridiculous, and you can't defend it that in 2021 we've got these 5 countries can control the world agenda, the world calendar. And if we really want to open up the door, that's where we really need to start. And it's just with that kind of political will and determination, and with that kind of change, that we will be able to tinkle about with the legal bodies. The law never comes first. Law always follows, and law follows a political will and determination. If we really want to change things, that's where we really need to have our focus. And institutions like this one, organizations like this one, play a crucial role. We need to remember why we are all here today. It's to know what human beings are capable of, and to say, no, we can't act like that. And if you do act like that, well, you've got a risk at internal, domestic level and international level. And in coming 10 years, it's the political will we need to focus on and recreate. I think you've understood it's a long road ahead, but it seems to be possible. And with people as we've got here, I think we can be kind of optimistic, and international justice isn't just possible, but thanks to people like yourselves, it will be all the more efficient here. Thank you very much. A round of applause again. Thank you very much. We're going to have a 15-minute break. Yes, a quick 15-minute break. For the people online, we will resume our session in 15 minutes time. And for people present, you can have a beverage. Thank you. immediately we're just sorting out our PowerPoint presentation. We're going to start off with Stéphanie Boissard, who's the head of research, archives and documentation at the Maison des Yeux. And she's going to present the Nuremberg album by the Charles Alexander photographer here. Hello everybody. Our star this afternoon is this album. We received it at the Issue Center. It was given to us by the Donnedieu de Vabres family in 2019. When we received it, it was slightly damaged here. It was an object that had been a family object. It had been naturally weathered because it was leafed through and it was playing a significant role. It was a souvenir album. It fulfilled its role as a souvenir album. When we received it, there wasn't any dust on it, which meant that it had been handled. Kind of slightly tired in terms of the bindings here, slightly weathered. Some of the pictures had weathered. It had played its role as a live object amongst live people. This object, the first thing we did was to restore it. This is its first official presentation following the restoration. It was performed by Maud Blanc and Charlotte Gasbrac. And they dealt with the binding. This beautiful object is unique. It was in the private papers and documents of Judge Donnedieu de Vabres, and thanks to the donation by the family, it's now at the Issue family. This was also, the restoration was made possible thanks to the American Consulate in Lyon here. This is a souvenir album. What's actually in it? We got pictures taken at the Nuremberg trial, and the photographer was Charles Alexander. He was a military photographer, official military photography, and he was with the United States delegation. A lot of these pictures have been preserved here. This album has got 116 pictures, and we've got a total of 130 pictures that we can find in the Truman Library in the state of Missouri in the United States. It's called Independence. It's a university library there. The reason is because it was during the term of office of President Truman that this military photography was working, so it went back with the American delegation in those days. 116 pictures here, the format, it's quite imposing. 28 by 34 centimeters, quite thick, 8 centimeters thick, and this was a present, a gift that was given to the Judge Donnedieu de Vabres during the trial. And when you see this object, you can see inside. The pictures of the inside will be displayed on the screen, because this object, this album is very fragile, so we don't handle it too much. The inside, we're talking about 131 pictures in total, which are presented as follows. Now, what kind of pictures are we talking about? Sorry. We've got pictures that are documenting the London Agreement. The Judge Falco representing France. The signature of the London Agreement. The city of Nuremberg. Contextualization before the trial actually took place. the investigation. And we could say this was the prosecution before the actual trial here. And we're documenting pictures that relate to the judges. We've got the 8 judges here that were present. And it's an album that comes to a sudden end. You see all the we see the faces of all the accused here, of the defenders here. It's an album that documents the actual preparation of the trial. A whole set of pictures that show all the pictures that were taken to really make sure that the trial could take place. You can actually see the room that was set aside, ready for the hearings here. It also documents the behind the scenes, which you can see. Sorry, not very good at that. That's the inside of the prison. A couple of pictures showing the interior and the cells, which we have seen before. And other pictures that document the catering, thanks to American delegation. Different goods were made available. And then this is really backstage as such. I don't know if you can actually see. This is a picture with a cardboard box on the left, and it says, you can actually see the stewardship. It says don't use the machine when somebody's phoning here. So that means that this pencil sharpener, this machine, was loud. So you can see, it's just to tell you that all the pictures that are present here are there to document. It's a souvenir album here before the trial, the preparation, during, pre, post and during the project, and also the defendants here. And then there's a specificity to this album. There's a page here with signatures. They are very interesting here because they clearly contextualize the object. When was it actually given to the judge, Judge Donnedieu de Vabres? 26th of July 1946. We've got this book signing, this dedication here. He received this during the trial. I mean, it's only in September that we actually heard the verdict here. There was the trial. They must have found some time to give this gift to the Judge Donnedieu de Vabres. One of the signatures is Mr. Jackson, who represents the United States, and dedication by Mr. Jackson here. It says for Judge Donnedieu de Vabres. Here it is at the initiative of the General Attorney of the United States, and it was at his initiative that the gift was handed. You've got the signature of all the other judges from all the other delegations. An additional signature of Max Welfive, who was the prosecutor for the United Kingdom. He's the only prosecutor who signed. Was he the only one present, or was there another reason? And once you can actually see this, and you see this page, you're thinking, well, it's clear that the judge received this gift, but it possibly means that the other judges, the 3 other judges from the delegations, must have received the same gift. Difficult to imagine that only the French judge would have received such an album. Our assumption is there must be 3 other albums, at least, that must be out there here. We would like to be able to find a similar album elsewhere, like this one, as it had the dedications. It says to Mr. Professor Henri Donnedieu de Vabres, who would like to find the 3 other albums that must have been handed to the 3 other judges. Since we can also see that all the judges here signed as well, we can see the alternates were there and signed it, like Judge Falco or Rudenko or the others. They must have received a sample as well. This is an assumption. We try to check this assumption out here. We tried to get in contact with American universities. Also checked amongst UK universities, and we've kind of, it's a warrant we've kind of issued. We'd like to see if there are any other editions, any other examples or samples out there. For the moment, we haven't been able to find any other copy. This is the only copy so far. However, I found a certain number of other publications, 2 publications, based on Charles Alexander's pictures here. 2 publications, 2 books were published. One very interesting here, which we discovered during our investigation, it's called Justice at Nuremberg. The pictures are the same, they're Charles Alexander's pictures. And Danke Chan wrote a text. He's a journalist and he's actually commenting the different pictures. This provided a definite interesting content. The legend was written at the time on the pictures presented, whereas in our album we're just talking about pictures without any title or legend. Something that has to be further deciphered here. It's true. This reminds us more of a kind of magazine than a book, but it's kind of a post-war conditions here. Obviously, it wasn't as easy to publish at the time. Now, this publication, we found a trace of it. We've got a copy here at the Maison des Yeux Centre. Got a couple of them on sale online, but in France there's another copy available at Nanterre, at the Nanterre Centre. We found another kind of work or book, slightly different, with hard back here. In that book, the pictures have got very short legends, a different format once again. You need to specify, I do need to explain the pictures presented here, the 116 pictures in the album, can be found in the previous magazine. It's basically the same pictures, but not the same support. In this book, the pictures aren't the same at all. They are documenting the trial, but they're much less focused on the trial. It's more so focused on what the delegations visited around Nuremberg. It's more, they're more targeting the general public, if I can put it that way. And the topic, obviously, is the trial, but it was much more so what was going on all around the trial. So pictures are quite different compared to what we've got in our album. Been able to identify this particular book. There are a couple of them on sale online. There is one at the La Contemporaine at Nanterre in Greater Paris, but it's mainly in the United States in different American funds and foundations that I was able to identify different works here, different books. In particular, a copy that was signed by Parker, who was an American alternate. And he donated this, and he had different newspaper clippings here, which he added. I'd like to mention, I'd like to thank the Wilson Library, which is located in North Carolina, Chapel Hill. Had a great contact with the American universities, and they weren't aware of this document, and they were very interested in it. And they really wanted to establish a link between the different documents here. So the university, the Wilson Library, they sent us photocopies of this whole book, and I was able to check the pictures that were used and to see the difference between the pictures you can see in this album and the pictures in this particular publication. And it actually was edited at the time it was published. Sorry, we can't see it. The Delaunay family apparently have seen the pictures. You guys have to repeat it in the mic because well, apparently in the Bonnet, the Bonnet Fund, which has just arrived here in the ISIU Center. That's the last fund. That's the general attorney of the Fund who was at Nuremberg. We received it this summer. That was the official donation to the ISIU Center, and this fund is going to greatly support the work we are doing. And I just found out that in this fund, apparently, we've got a copy of this book, which I just mentioned. So it's going to be very interesting to look into it, and even though thanks to the American university, we had an idea of its actual content. More than interesting. We didn't, obviously, we had a quick answer from the United States, and we're waiting for an answer from the United Kingdom and also from Russia. We still are asking for further information from anybody who may have information. We've understood that the main issue, we talked about an object which is a private object. It belongs to families here. We were very fortunate to receive it from the family of the Judge Donnedieu de Vabres. So it's a bit more complicated than when we are talking about public funds or public material or things that are probably less emotional here. Obviously, when it's public archives, it's much easier than when we talk about private archives.
Thank you so much for that presentation, Stephanie. So now we're going to continue. This time we'll be hearing about the racial issue before international justice, and so it is Guillaume Moralis who's going to speak to us about this. He's from the CNRS National Research Center, and he's a specialist on these topics. He did his thesis was Franco-German, devoted to the judgments of the crimes of Eastern Europe. You have also written about Nuremberg and the judicial experiment. Il est illisible ce truc. First of all, thank you for inviting me. I'm delighted to see some people that I've known for quite some time. I'm happy to see so many people interested in the Nuremberg trials. In the United States, racial discrimination of the past and present are rarely thought of in terms of international law. Particularly, we talk about penal clause. So when we talk about hate crimes, for example, when we talk about unlikely reparations for slavery and, or the endemic racism coming out of discrimination, we tend to refer to domestic standards and norms. And yet, just after the war, this isn't going to work. So from 1945 to 1949, experts from the American government have actively contributed to putting together the norms which would establish racial discrimination. Vous n'avez pas un pied de micro pour lui? And so some of the works on this topic are soon to be translated. But this was a brief parenthesis in the American history. So one of the major expressions of this passing internationalization was the prosecution of the 24 Nazi leaders, which was an entirely new and experimental judicial effort. So in my work, there are 2 points I want to make. We must conduct a sociography of the stakeholders, first of all. And so this is why I believe that a systematic study of the careers of the justices of the IMT, International Military Tribunal, is absolutely necessary. So there were innovations at Nuremberg, but I also wanted to see what were the individual backgrounds of the judges and prosecutors, because we must we must never confuse judicial practices with judicial concepts. So the category of crimes against humanity and genocide were in response to the racial policy of the Nazis. There was some very difficult work done around this concept, and yet it is occasionally absent from certain studies. So there is a link between the racial studies and racism in the US, and so I'll be looking at some of the different aspects that link the two and how institutional racism is considered in the United States. The speaker is reading a document which was not given to the interpreter, so I apologize. So, as I've said, this was a judicial experiment. The Nuremberg trials brought together practitioners, including American lawyers, who dominated the trials and gave it a certain tone. But there were other constraints or biases at work, which were ethno-racial in nature, and that is what I will talk about today. We can see this in the way the crimes were defined and for their punishment based on race. So, Article 6C of the IMT, persecution for political or racial or political ideology are part of crimes against humanity, but it's restrictive because it doesn't speak of a individual crime. So it does not speak of conspiracy. And then the charge of proof is heavier because it would have to be proved that the extermination of the Jews by the Nazis had to be limited to the Nazi reign, and therefore nothing before 1939 could be considered. But the New York lawyer, Bernays, who was an expert at the War Department, and said that repression of racist crimes raises the problem of minorities. That's how he called it, the minority problem. So calling racial atrocities in the war could create a precedent to judge the conduct of states against their own citizens. This could open the way to huge political upheaval. Here, the question is to punish these atrocities if it is in the context of an attempt to achieve global domination. And so it was hostile to the idea of a more broader definition. And so it raised the fear that the Jim Crow laws and lynchings in the southern US states would be covered by this international law. And there are many, many examples of the response to this. During the London negotiations in 1946, the Robert Jackson, the head of the American accusations side, emphasized that the way in which Germany treats its own citizens is not our concern, no more than it is for another government to take an interest or interfere in our own affairs, where it might be considered that some of our minorities are mistreated. And so what we could see underway was this process of trying to neutralize the notion of racial crimes. What was going on here? First of all, after the war, the racial question for the United States was something that people tried to set aside or ignore. In 1944, efforts had been made to widen the scope of these laws. And in 1946, the fight against the Nazis was associated with the defense of the white race. And there are many other examples. Sidney Eidelman, a Southern lawyer, wrote in his journal, the judge is quite appreciative of Southern culture and particularly appreciates jokes about blacks. So the federal government had received reports. These experts were trying to legitimate the states' rights, and the defense of sovereignty means protecting the domestic, everything that is considered a domestic affair. Racism is a family affair, and it cannot be exposed to external international consideration. My second point, we mustn't be surprised that the American lawyers then adopted rather conservative positions, rejecting, for example, the Universal Declaration of Human Rights or the Convention on Genocide. But there is one very instructive case, and that is the Judge Jackson, Robert Jackson of the Supreme Court. So you can see the court here. And this is from 1953. We know that Jackson voted for the Brown versus the Board of Education of 1954, which ended segregation in schools, and we know he did this against his usual position. He found it difficult that the Supreme Court should eradicate fears, pride, and prejudice in society. That's not the role of the Supreme Court. And so, according to him, nothing in the Constitution prohibits segregation. And so, if we want to speak to those who suffer segregation, well, he also wrote, well, we must also take into consideration the people who must give up the segregation. So he has a rather interesting career, a very conservative judge. He was very much linked with upstate New York, Jamestown, where he began his career in 1934. He was close to Roosevelt, and then he became Minister of Justice. During his times in Washington, he was faced with the inflexibility of the Southern Democrats. When he was appointed a Supreme Court judge, he stood back, was not in the forefront on matters of discrimination. The Warren he tended to vote against affairs brought by black citizens. He was often undecided about questions of school segregation, and so he appealed to the white South. But he said to those close to him that this was a source of internal conflict for him. And in an opinion concerning the internment of Japanese citizens, American citizens, he dissented. After 1946, we saw a split in his opinion. And so, in the case of Jackson, he was very skeptical about the social role asked of the Supreme Court, and no doubt stemming from his close ties with the South. And so he carefully avoided drawing conclusions from his Nuremberg experience. In 1947, Jackson praised the work of the IMT when he spoke before the National Bar Association and spoke before the Black Bar Association. And he made no reference to the domestic racism when he congratulated Nuremberg on its decisions. Francis Rivers said that the principles of Nuremberg must be seen as a crime. All Americans must consider racism as a crime, as it was considered at Nuremberg. So Nuremberg was considered as a landmark for mobilizing people against racism. So this fight for civil rights could begin in earnest. So the NAACP in the 1930s had already started a work via test cases, picking some key cases that they hoped to bring as far as the Supreme Court, including in their work for the victims of segregation. As of 1945, they often pointed to the national treaties signed by the American government, such as the United Nations charters. And so the articles in the United States charters condemn racism sometimes the racial clauses in contracts were finally declared unconstitutional. But human rights so often in the United States, in their defense, civil rights lawyers were very familiar with the Nuremberg trials, but understood the limitation their application in the United States. So, for example, in mobilization against lynching in southern states in September 1946. Well, I won't comment on that article, but the title says it all. Put lynchers on trial with Nazis, asks the DSC. So in September 46, so as the Nuremberg trials were ending, there were protests against lynchings organized by Paul Robeson in Washington, D.C. It was very tense between the organizers and President Truman. Racial discrimination in this country, according to participants, is as evil as Nazism in Germany. And the President Truman responded domestic problems are domestic problems, and external problems are external problems. End of the question. And so it's true that the impact, here you can see Robeson in that picture, and so in the battle for civil rights, African American organizations sent petitions to the United Nations, and those documents are amazing in several ways. They looked, there was an attempt to widen the scope and bring it up to an international level. And they were, in fact, even demanding an international court, such as the IMT. In 1951, William Patterson, a communist lawyer, with the support of Paul Robeson, this 250-page work, the result of a very long study, is a long list of charges against the guilty. In the opening statement, it takes a model from the Jackson's opening at Nuremberg. It's interesting to note that this petition led to a very tense exchange with Limken. Limken was showing a lack of empathy for the African American cause. So this is of note. So to conclude, the Allies tried to reduce the racial question. So it was a trial under constraints. There was a desire to try to avoid this color line of the United States. And as we look at Max Weber's analysis, that there's a certain amount of irrationality going on here. Crimes against humanity creates a particular law for particular cases, and for this reason, we might find it very striking, this institutional position, and yet they were very much picked up by the civil rights movements. And so we can see a great disconnection with human rights in the broader sense. And so Nuremberg was really a parenthesis in the Americans' racial affairs. And so we mustn't have any illusions about this retrospectively, that the 1945 trials might have given them momentum, but it was nonetheless just the beginning.
Thank you. I think early on. It's a longer road to move towards international justice, and you've seen the various side roads that have been taken over the years before we actually can reach this. Don't you? I think Dominica wants to say something? No. Yeah, sorry to interrupt this discussion. Just 2 minutes here. Part of the Geneva-based United Nations delegation will have to leave us. I don't want to interrupt Diane Marie Aman in her presentation, so I think it's preferable that the delegation that has to leave us do so now, and then we can move on. We're unfortunately running late. So do you want to say something? I'd like to thank in the name of Geneva delegation, the Maison Center, the coach will be leaving in 5 minutes time for Geneva, because it takes some time to get back to Geneva. Thank you very much for your whilst Jan prepares the presentation, what we may do to avoid having to cut off the last presentation, I'll take the responsibility for that. We won't have a coffee break. Then we'll be able to catch up the time which we are lacking so far. Now, at the end, Marie will be making her presentation. She'll have 20 minutes, and then afterwards, the last sequence will take place immediately afterwards. We'll be listening to Jean-Paul Jean, Mathias Gimenez, and Laurence Le Tourmy. So we won't have a break until the end of our session. Thank you very much. Bye to our friends from Geneva. And if you want to get a bit closer, you as teachers and professors, you know it's unpleasant to have empty seats here up front. If you can all move forward, that would be more than agreeable. Thank you. Please resume your seats as fast as possible, because our next speaker has to leave in 20 minutes' time. And we don't want her to come, especially from the United States, for nothing. Is everybody ready? Can we start? I think you've seen that it's a very important question. We talk in the role of lawyers and other exceptional women at the Nuremberg trial. The floor is yours. Thank you very much. I really would like to address my thanks to the team of the Maison Center. Yeah, once again, I really would like to address my sincere thanks to the team of the Maison Center and all the people participating in this colloquium. It's a great honor to talk to you about the role of women lawyers and other exceptional women at the Nuremberg trial here. This is a very moving moment for me, not just for obvious reasons, considering where we are located, because my own grandfather spent his youth in an orphanage in Washington, D.C., in the United States. I'd also like to thank the United States Consulate and also the families of these women, especially Mr. Michel Chalofaux. An anecdote will be my means of introducing my subject here. Early February 1946, a Parisian in the 70s who wrote a letter to his daughter who was at Nuremberg. He quote, had a week without newspapers, but were able to follow the trial before and after. She's referring to the trial of Nazi criminals. And as Trisolet, famous author, called it the trial of the monsters here. It started in November 1945 at the Palace of Justice of Nuremberg. When this letter was written, the trial was already halfway through. This was when the French prosecution was representing its witnesses against the defendants. The letter continued. I saw a Spanish witness. Is it the one that you had come along? Now this question from a mother to a daughter. This is exposing an unknown aspect of the trial. A lot of women worked at Nuremberg and their contribution before, during and after the trial. So the contribution to the very success of this trial was more than significant. This beyond the fact that the traditional stories and narratives tend to only focus on men and never on women. Typical picture of the hearing room of the International Military Tribunal. Here, IMT. This black and white picture is representing a pretty grey image. 100-odd men are present. They're kind of either bald or grey-haired. We can see prosecutors and we can see the press. And we're fully aware that in front of these men there are other men like judges, lawyers, defendants and the accused. Having said that, if you look at things a bit closer, you realise, number one, that about 20 people present in the room are in reality are women. Second thing is, nearly all these women aren't observers, but seem to be playing an active role within this trial. Based on my research, more than 200 women worked either for the IMT or for the 12 trials that came along afterwards. Those were who worked as lawyers, as assistants, as journalists, and as analysts, and as interpreters, simultaneous interpreters. They occupied nearly all the roles except that of a judge. My project is to make these women visible, these women who up to now have been kind of in the shadows here. Now, if I consider the first 6 exceptional, now we've several British who helped building up the file against the Germans. Suddenly, Tatiana Stupnikova, member of the Red Army, who was the head of the simultaneous translator team. She's the only member of the IMT to have published a book on her memories of this trial, whereas there must be at least 40-odd books, similar books, written by men. Then afterwards, we've got the American lawyers, Catherine Veit and Harriet Zetterberg. And the 5th woman is Edith Simon, who's a translator, interpreter and analyst. In Germany, we had Harriet Zetterberg, who had escaped Germany and went to the United States. She went back to Germany as an American citizen who studied at Berkeley. Now, those 5 women are exceptional women. They're well educated, multilingual. Each of these women played an active role during the war, and they each spent the first year after the war not at home, but at Nuremberg. A strange life, a life where everything was in ruins here due to the bombing, and a life where women weren't always respected. This last point definitely applies to the German women, because they were defined as being either war criminals or prostitutes, but it also applies to the other women who were present there. Often they were either treated as victims or as purely romantic subjects of interest and not as professionals here. In the end, the sixth woman was Aline Chalouffour, who received the letter I mentioned at the very beginning. Aline Chalouffour is slightly outside of this group of the 6 women. She was probably the eldest of the 6 women. But the career of this French lawyer really stresses the exceptional dimension and side of these women, as we'll see. So now, some 1944, Edith, Harriet, Catherine, Tatiana, Betty, Aline, they were going to... now we realize that Aline Chalouffour was trying to get away here, and all the other women had left Asia. Then afterwards she had established propaganda in Canada too. Then Chalouffour responded to the call for the Ministry of Justice, who was exiled at the time in Algeria. When she was in Algeria, she found that the team had already been moved to Paris, that had just been freed. So that's Aline Chalouffour. So she came back to France, and she went to Meudon, which is not far from Paris, and she was there with her 7 brothers and sisters. 2 of her sisters were engaged in the French resistance. One of her sisters received the Medal of Resistance. Aline Chalouffour, she stated in a written letter to her bureau at the Ministry of Justice in Paris, she said, "My work is dealing with the responsibility in terms of commerce. It's sinister but useful. The Gestapo did never display any pity and acted in a monstrous, incredible way. My work is to establish the crimes that were committed and to find their authors here." As a feminist, she wrote an article for Marie France, the Marie France magazine. Autumn 1945, Mrs. Chalouffour was appointed to the French delegation in Nuremberg. Before she was appointed, she had been a student at the Sciences Po University and at the Sorbonne University. She was an assistant professor at Harvard and Geneva, and she was a professor in 3 universities in North America. She had already written a book and many articles. She was also the 6th French woman to have obtained a PhD in international public law. Now, for this very first international trial, she was just there, seen as a project manager and no more. And she wasn't considered as being a possible lawyer, jurist, magistrate or prosecutor. Now this woman who was 46 years old, she was called not doctor, but she was called mademoiselle, whereas she was a doctor and she was a lawyer. She was a barrister. Now her and the 2 other American lawyers weren't allowed to take the floor at the IMT. Each document that was prepared by a woman there was always presented by a man. And the men were the only people to speak. In the best situation, the women were just sat down at the table behind the men. This stage brings us back to the anecdote I mentioned at the beginning of my presentation. We're talking about a hearing That happened to be an afternoon in January 1946. Charles de Vabres, who was the chief deputy prosecutor, called upon Mr. Charles de Vabres. And when in fact, this was Dubois. He was a child soldier in Spain. Mr. Dubois was locked up in Maison at Nuremberg as a witness. Sorry, Bois, not Dubois, Bois. As a witness, not only did he talk about the atrocities he'd witnessed, but he showed them. A journalist described the scene as follows. On a screen that had been put in place, an operator showed in front of the people these pictures he had chosen amongst those Bois had saved from the camp where the Germans had used him. This witness, his testimony was highlighted during the previous summer. An American report stated that Bois most likely gave those pictures by providing testimony before the inquiries to the French Ministry of Justice in France. Now, who was the investigator? Well, it was Alain Chalofaux. Thus, during the testimony by Bois, and Dubois was standing on stage, sat nearby, we've got Chalofaux, and Dubois is reading a document aloud and is questioning, and a witness, you can see Chalofaux just following. So in fact the answer to the question, the letter which I mentioned at the beginning of my session, her letter, well, yes, Alain Chalofaux made sure that one of the key witnesses was brought to Nuremberg. Just after the IMT at Nuremberg, the British held another trial on crime here, and the statistic actions that took place at Nuremberg, the British had accepted the presence of a French prosecutor, and because that person spoke English and German here, and it happened to be Alain Chalofaux who was appointed. She, at last, was able to uphold her title as prosecutor, but this trial must have frustrated Chalofaux. Most of the participants were once again men. Having said that, now, this time, we can see that we've got women who actually are defendants here. There are 7 of them. We've got Carmen Maury, who was always made up and always had a fur coat for the role she played. Chalofaux said that the British preferred to focus on the atrocities and not the important things here. So, what was that according to Chalofaux? Well, let me quote her here. They ignore the extermination plan of the Germans, of the members of the resistance. Her written complaint expresses a feeling of frustration. Chalofaux had appointed as the alternate with the very specific condition that the person and was accepted, but she wasn't allowed to take the floor. And after those 2 trials, post-Nuremberg, Alain Chalofaux revealed herself once again as being an exceptional woman. On the contrary of the other members of the IMT. She published 2 articles pertaining to the trial, one within the newspaper Le Monde and the other one within the yearbook of The Hague. And in 1949, Chalefour became one of the 21st women judges in France. She ended in 1966 at the Palace of Judges of her city of birth, Dieppe. In conclusion, I would like to provide you a last anecdote here. She had to wait for 3 years before becoming judge. For 3 years she stayed in Nuremberg. She co-managed the preparation of the French version of the Blue series, Les Séries Bleues. So we're talking about the 42 volumes with a blue cover containing all the minutes of the IMT. Later on, this project led to a significant discovery. And it was a telex that stated, this morning the Isieux home was dissolved here. In total were arrested 41 children aged 3 to 16. End of quote. As described in a book written by the organizers of this colloquium, the future investigation confirmed the author of this telex, and it was Klaus Barbie, who was head of the Gestapo in Lyon. In 1987, one of the key reasons for condemning Klaus Barbie was this telex that was found within the Blue series, the Série Bleu. And thus we can trace a line right from the roundup of the children here in Isieux, right up to Aline Chalefour, one of the many exceptional women at the Nuremberg trial. Thank you very much for your attention.
Thank you so much for that presentation. That was absolutely fascinating. And of course, drawing the link to Isieux is wonderful. So, Dominique, who do we have next? Well, we're going to now be hearing from our 3 next speakers who will come up to the stage. So I want to thank you all. So I'm going to have to leave you, but thank you so much, everyone. I just did us out of a break, but didn't really need it.
What?
There's not going to be that break.
No. Hello, everyone, ladies and gentlemen. I'm delighted to be with you today. So I'm Mathias
Gemelik. I teach at Mainz University, and I'm going to be talking to you about General Delphin de Bene, who represented France at the Nuremberg trials. But just a few comments, first of all, about the French delegation that was put together for the trials, so that we get all of that clear. So in 1945, after the London Conference, when the Allied powers agreed on organizing a major trial against the leaders of the Nazi Party, and to create, for the first time in history, an international court, which was the IMT, and different delegations were chosen. In the four countries, so the United States, Great Britain, the Soviet Union, and France, the preparations began. On the French side, it was the Ministry of Justice that was choosing the team that would represent France and recruit the staff. We knew that this would be undertaken in Germany, so we would have to have all types of staff, interpreters, translators, assistants of all kinds, and so the Department of Justice did this. About 250 people were hired and sent to Nuremberg. So when we talk about the delegation, in fact, it's those 250, 260 people, which is a large number, particularly when we compare with the other delegations. The Americans were, of course, more numerous. They were in the American occupied zone, whereas the British and the Soviet teams were far smaller. So that's one observation that we can make, that the French delegation, in fact, was the second largest. Within the delegation, there were also legal advisors who were participating actively, would speak at hearings, who are present in the hearing rooms, about 15 legal specialists. And so we have the two French, on the French side, we have the judges, Judge Donnedieu de Vabres and Robert Falco, and you've already heard a bit about them. And then we have the representatives of the French prosecutor, public prosecutor. So we have the lead prosecutor, François de Menthon, a well-known politician at the time, former head of the judiciary. And then we have Edgar Faure, Charles Dubois, and Delphin de Bene, and two others. Well, what is interesting about Delphin de Bene in this story? Well, first of all, when we look at his career up to Nuremberg, we can see that it's a very exemplary career compared to the careers of some of the other French prosecutors. First of all, he's a magistrate, so this is the first important point. Delphin de Bene is chosen, amongst other reasons, because he is a magistrate himself. He was born in 1907 and became a magistrate in the 1930s, first in Rennes, Poitiers, Niort. And then in 1945, it was decided that a high-level magistrate should be sent, and some of the leading figures. Then there's a whole other list of precise criteria for selecting the magistrates. So we would see magistrates who had linguistic knowledge, which are useful. So who speak either German or English or Russian even. others who had led investigations against collaborators during the occupation in France. Another criteria was to choose people with knowledge of certain domains. So, for example, there was the financial pillaging of occupied countries. And so this is why Paris was also recruiting experts in financial and economic matters. But this one really particular criteria. It's having been a member of the resistances. So at Nuremberg, this for the French government is a matter of credibility before an international audience, in fact, to denounce the crimes of Nazi Germany. And this is why it was important to pick people who had fought against the Nazis. And so Delphine de Benet was a well-known resistant fighter. He had been mobilized at the beginning of the war, but then after the invasion, well, he was sent home, but then he began participating with the resistance movement. And he was arrested in the summer of 1944, in fact, by the Germans, and his in fact he was deported to Buchenwald in Germany, where he was held for 9 months before being liberated at the end of the war. And so he's not just someone who was a notable resistant and known for his courage, but he also paid very dearly and suffered personally at a German concentration camp. And so this is these are amongst the things that made him an ideal candidate. So when he arrived at Nuremberg in October 1945, just before the beginning of the trial, and so the question arises, well, what was he doing exactly at Nuremberg? What does a French prosecutor do at Nuremberg? So de Benet was on the French prosecution team. So what do we mean by that exactly? So the trial was divided into 2 phases, so in a rather Anglo-Saxon manner that you've heard about. So the first half was reserved for the prosecutors presenting the charges, and the second part was for the defense side to present the defense. So the first phase is for the accusation side, and so there are the other allies as well. And the 4 delegations agreed that each delegation should speak one after the other. So the Americans began, then came the British, then the French, and finally the Soviets. So there was this whole phase of the trial that was set aside for the French prosecutors to speak, starting in December 1946, and then 3 weeks later, the French prosecutors had completed their presentation, and so their assessment of the situation and the German crimes. And so this was also the opportunity for the French side to distinguish themselves from the other allies. And I think this is why the de Benet's case is interesting, because he himself, he embodied and defended the ideas of the French prosecutors. Let me give you an example of that. One of the characteristics of the French prosecution was the collective culpability, the collective guilt. This is something that the French were putting forward, and that François de Menthon put forward, and that we can see all across the statements of the French side. So that, yes, we have these 20 indicted people, but at the same time, it was considered an international forum to insist on the fact that the guilty parties are not just these 20 people, but the German people, the entire German nation. And so and so the French were in open disagreement with the other delegations. For the Americans and the British, their idea was around that there had been a plot, that the accused were part of a conspiracy, that they had tricked the German population, that they seized power and then started a war. So that was the position of the Anglo-Saxons at Nuremberg. So there was no broad guilt for German society. And on the Soviet side, the guilty were the fascist clique, who were allied with industrialists and bankers, and that had subjected the German workers. So they were also against the idea of a guilt of the entire German people. And so it was only the French who were putting forward this idea. There was a political intention behind this, because the reconciliation was far off. It was also a personal matter for the prosecutors. And so this is why Delphin Dubenet is quite an example, because when he talked about the collective guilt of the Germans, he was speaking from his personal convictions, and so he defended this position several times. And he stayed at Nuremberg until the end of the trial, nearly. Then he returned to France, and he became a prosecutor in Lyon in the 1950s, and then a judge, and then at the Court of Appeals in Paris. And then, well, he gave quite a few conferences, particularly at the anniversaries of the Nuremberg trial. And so this is a theme that we find again and again in his memoirs, that the French prosecution wanted to pursue the guilt of the German people. And so this was definitely the position of the French prosecution. So the idea of collective guilt is one thing, but he also wanted to to ensure that international justice would be exemplary in its judgment. So today we have the International Criminal Court, and we know that this was, Nuremberg was the first time that an international court existed. And so at the time, it was not so clear for everyone to understand the authority of this trial and to try to understand either if this would have any impact after the trials on international law. So many saw the trials as simply punishing the guilty, and that this would not have any impact beyond that. But the French didn't see that way. So in the French delegation, we can see in their notes and statements, there is this idea that this should be the beginning of building a new type of court, and that it should be a permanent institution. So this was an idea that Dubenet was also very much in favor of. And we find this again and again in his writings. He wanted these trials to set the standard. Another point that is important about Delphin de Bene is his contribution at Nuremberg. So it ended in October 1946 with the conviction of most of the accused. And so today we can see that those accused were convicted on the basis of documents which had been presented by the French delegation, in fact. And de Bene himself put forward very damning documents. So Inkvot, the German head of the Netherlands, who was involved in the cross-examination, here the accused comes to the bar, the lawyer asks questions, and then a prosecutor asks questions who tries to refute the version of the accused. And so Inkvot, well, it was questioned by Delphin de Bene after the defense, and he presented several documents about the execution of hostages in the Netherlands, the deportation execution of Jews, and the pillaging of the Netherlands. And when we look at all of the papers, well, this led to his conviction. So we can also say that it really, thanks to the proof provided by de Bene, that the Nazi governor over occupied Netherlands was convicted. It's also important to note that because we can see that the Nuremberg trials was very much an international trial. It wasn't just an American undertaking with parties from all of the countries involved. So, thank you for your attention.
Thank you very much. Put on the screen, this is Matthias's book, which has just been published in German about the French delegation. I'm very happy to be with my two friends, Michel and Matthias. I got to know Matthias when the Delphin de Bene was inaugurated at Lyon, at the Court of Justice there, and that's where we got to know the son and daughter of the list, and these two are actually present today. And they gave us a very interesting, a very moving personal archivist. And Dominique mentioned this earlier on, the fact that we've got these three magistrates here. Those are the three files and archives that were given by the three families here. De Vabres, de Benen and Falco, very interesting. I'm the magistrate. I'm at the Cour de Cassation, which is the Supreme Court, but I also work for the history of justice in France, and Pierre Truss had initially focused on that work and his role in particular in the Barbie trial here. I'm very interested in, and that's the role Matthias talked about these what I call resistant magistrates who went to Nuremberg. What I'm interested is to see how the magistrates, and that's the title of the book I published, which is a collection, Judge Vichy, and then afterwards which magistrates chaired the sessions at Nuremberg, and none of the members of the accusation were at Nuremberg just by chance here, members of the prosecution, so it's interesting to see the link here. In particular, Robert Falco and Delphine Deganis. Now, Robert Falco, he wasn't well known at all at the time, before the publication of his journal by his children, his Nuremberg journal. Now, the only image which we have of the Judge Robert Falco, and we can see this in the documents by Taylor, so I need to speak a bit closer to the mic, it's true. In Taylor's document, he describes him as a kind of small magistrate, because he always enters the room first here, and he's going at a fast pace, and de Vabres, Donnedieu is next to him here, and he's the only one who's wearing his decorations here. None of the others debate about what they should dress, what they should wear here. It's described by everyone, because he was a judge, and judge they don't often talk except for the president of the hearing here. Somebody discreet here, and they very often don't hear about them, and it's his journal, and able to get to know him better. And it's this man now I'd like to describe, thanks to his journal and what his family told, and personal investigation around Falco. Now, I'll talk about him briefly. He's a man of great general culture. He was a lawyer and then a magistrate. He was a secular Jew excluded by the Vichy regime. He was excluded in December 1940. He became a refugee in the free zone of area of powers, reintegrated after the liberation of France, and then in London, the London agreements that created the International Military Tribune for France, and he then became a magistrate alternate, and he's the one who will draft a report in terms of a rehabilitation of Baudelaire for the Fleur du Mal. He loved poetry here. He dealt with that. Begin Baudelaire, Charles Baudelaire back here. Now, let me start off with a scene that took place the 13th of July 1946. Quite surprising. It's a weekend, and the judges listened to the defenders here in the exchange between the Judge Laurence and Judge Falco. They're walking next to the lake here, and they're talking about Frank's, what he had said, and they're talking about Streicher anti-Semitism here. And Robert Falco said, and this was the play, and Falco, we could believe it, the measures that were done against me, it was by the French government. It's when I told them that I was tossed out of my court by the French state, and I had to hide in the south of France. So 8 months after the trial opened, Judge Laurence discovered that Falco was literally thrashed by the Vichy government, and Falco is the only particular person in that case by being persecuted by the Vichy regime. And the other lawyers, which we mentioned earlier on, Dubast, who we heard about, the excellent communication and presentation by him, Serge Fuster as well, another lawyer. I had the pleasure to meet him. Serge Fuster is the pseudonym of Casamaya, for those who know. That was before the syndicate of magistrates, Herzog, Gartoffer, and the only resistant was Delphine de Bonnet, who went via one of the camps, Buchenwald, and he was a war prisoner who we can see next to de Menthon. And de Menthon makes his presentation, his discourse. So this question about identity, and Falco spoke to Francis Purdue, an American judge. I'm quoting Falco when he's writing this. Widow, very proud to be the authentic descendant of a red-skinned prince, and he He really has strong blue eyes, still blue eyes, and it's quite interesting to hear about that, considering the perception of the Americans. So throughout the trial, Falco will note down in a remarkable style all his impressions regarding the hearings with a subtle kind of appreciation. There were a lot of women actually drew the various scenes here, and he just jotted down impressions of the trial. And 65 years after the hearing, after trials, you can see what's going on in the mind of a judge. I know, because I'm a judge myself. We always have the impression of journalists, but what do the judges think at a given moment here? Let me take 3 or 4 examples. Even though it's writing 65 years later, we can at last discover the thoughts here. Common examples, extremely well. 28th of November, that's when was read the transcriptions of the telephone recording between Ribbentrop and Göring about the Anschluss and when they entered Vienna here. And we heard Göring, who's at home. He's having a coffee on his balcony. This is what I can hear on the radio. The acclamations when the Führers entered, the birds are chirping, and I'm happy. And the German delegation, they're just laughing. And Falco said next day, but Göring isn't laughing as much. When the next day, to talk about atrocities carried out by the Nazis, they showed the films that were shot in the camps here, when we can see the poor prisoners that are released. We can see people that can't even stand up here, pieces of cadavers that are moved by bulldozers. We can see the gas chambers and all that. The accused that are lit up in the room with the theatrical lamp, looking at these terrible pictures here. Kaijo seems to be impressed, whereas Sal seems not to want to watch it. He immediately found the right words here. The testimony, Robert Falco, like a lot, were impressed by that. Marie-Claude de Courtoyer, like everybody, in terms of her sheer sincerity here. And the words used by Falco were, she with a prophetic honesty and a contained honesty, describing the atrocities she saw here. By a vibrating tone, notes of a human emotion appears for the very first time in this room here and in this trial. And because otherwise it's highly documentary and technical, the overall ambience here. He also perfectly understands who's dominating the debates and the discussions. You can say Jackson, he's the main prosecutor, but he's very impressed by Göring. Quite dominating the room at the top, where he's throning as comfortable as if he were chairing the Reichstag. I wouldn't say he's admiring, but he's very impressed by Göring. The amazing dialectic skills of the man, at the same time quite charming, very authoritative, and obviously the people are listening to him. He's insisting on the duality between Jackson and Göring, and it's the latter that sees the advantage. Representative of the prosecutor. Jackson is impatient here, difficult to fight against this rock and this intelligence that has an answer to everything. The American prosecutor, who is totally miffed here, and he asks the president of the session to do something about, and Jackson is no longer on this pedestrian stone which he was on. He started with Göring, who is actually clearly the king in the room. And the last example, Falco is listening to the testimony of the head of the Auschwitz extermination camp. A small and a soft man who declares having personally sent to the gas chambers over 2 million people. They presented this radical measure to stop the Jews destroying the German people. Now, it's always the same restraint from an emotional point of view, but what is Falco actually thinking himself? I mean, he's very displays a lot of pudor here when he hears us or Streicher or Frank Göring, all these anti-Semitic Nazis, and amongst the 8 judges there, does he know that one of them is a Jew, and that Jew, who's a magistrate, was excluded by the French Vichy government because he was Jewish? So he was evicted as not being able to be a judge in France and a magistrate in France, and then he becomes a judge there at Nuremberg. He was excluded the 17th of December 1940, like 48 other magistrates, by the Ministry of Justice of France at the time, just because he was a Jewish here. And the general Pétain himself, and I showed that, he actually extended those people that would be discarded, and he actually stated that during the Ministry of Council, we can't have any Jews as magistrates here at the time. That's what Pétain said. A couple of months beforehand, Robert Falco was aware of it. He'd already been in the army during the First World War, and then he came back. He's listening to the radio. He's a refugee in Carcassonne, south of France, in June. Listening to the radio, we can see the violent anti-Semitic campaign, and that we can start hearing in France here. So he's excluded like all the other Jewish magistrates without any of his colleagues displaying any support whatsoever. But at the same time in Brussels, the first president of the higher court, and he publicly announced the exclusion of Jewish magistrates. Public statement towards the Germans here, and he was totally against the status of the Jews in Brussels. And he says that there's no problem whatsoever in having Jews present as magistrates here. Now, Robert Falco tried to stay as a magistrate. He tried to write a letter. Don't you think it's a bit excessive? Discrimination would strike the last balance, and if you consider the different regimen, don't forget that France is France. Robert Falco was always French before being a secular Jew here, but we'll see about that immediately afterwards. And there are lots of interesting letters. The State Council, so President Porcher, who's chairing this council, because now Robert Badinter afterwards, but at the time in the Second World War, it was said, no, the general, we don't consider that Falco had particularly served the state here. There's no reason to justify any exception for him, so he can't be a magistrate anyway. Coming back to what Laurent said, yeah, he hid in a small home which he built next to Toulon at Saint-Paul-de-Vence right until France was freed. And he read a lot at the time, and at the end he tried to move about here. He regretted the fact that some of the high magistrates wouldn't talk with him, and some other lawyers decided to shake his hand and not others, and he wrote this down. It was very displayed a lot of pudor here. In 1944 we received a telex here, and he went back here, and I won't go into that particular detail here. Now we're talking about the trains weren't working at the time, but anyway he went back here. Coming back to a couple of episodes of his life here, and which explain how he ended up in Nuremberg. He born in 1882. His father was a diamond dealer. Very much, it's a French family who state themselves as being found. A secular, as I said earlier on, a big family. He became he had a PhD in law. He loves culture, and he wrote a thesis, as we saw earlier on, in terms of the rights and duties of people when they're at a theatre here. But he's secretary of the Stasi. He became a lawyer then. He actually found, as a young lawyer, you'll like that, Mr. Keita, he defended in 90 somebody who had actually raped a child here, but he avoided a person to actually be decapitated at the time here. He was always against the death penalty. Now, why did he become a magistrate? He was a business lawyer, a corporate lawyer, and he said he was being a corporate lawyer he was afraid that he wouldn't be able to live anymore, and he decided to become a magistrate. He was kind of bored stiff. You could really... And in fact, he became a prosecutor at La Seine, at the courts there. He was noticed as the man who didn't speak at Nuremberg, who was one of the best speakers, very intelligent. He can smile, at the same time he's very dangerous here. As I said, he's extremely powerful in terms of using irony. He's quite an adversary for defendants here. But this man, he never was for the death penalty, but the prosecutor asked him to assist one of the last death penalties in front of the prison of the Santé. He will be the general prosecutor who will sign the document, and in front of the last death penalty that took place, because it's in 1939, it was no longer a public kind of death penalty. It was actually done within the prisons. In 1940, he came back to his normal life after this dramatic interval here. 1944, sorry, and then he realized that he was appointed here. Then he found out, and the first president was actually imprisoned because for 1 month he had actually been the Ministry of Interior for the Maréchal Pétain. For the first time in his life, he was appointed as a judge at the High Court, who had been a prosecutor throughout his life. So that's what he actually stated in June 1945, whereas I was working at the Court de Cassation, which is a Supreme Court, and of Pleasant. I was asked to become a magistrate at an international tribunal here, and they asked somebody who could speak English. He hadn't spoken English for 30 years. He was the only candidate who spoke English, and he was the only candidate who put himself forward here. And at the end, he thought he would represent, really, you're going to go to London. He thought he was going to represent the public prosecutor's office, but at the time, the people didn't see the relevance at all. He's got no particular mandate. He doesn't know what he's doing in London. Professor Gros is with him, who's a specialist of international law. He's welcomed by the ambassador, and who couldn't really care less. Hasn't got any particular instructions. Whereas Robert Jackson and the American delegation, they've anticipated everything regarding the IMT, as you mentioned earlier on here. He's opposed to this notion of conspiracy here, this kind of notion of a collective conspiracy. The French delegation was totally against it because it's not within France's culture here. He'll try and introduce a couple of notions of French criminal law, but he'll sign in the name of France, the 8th of August, the agreements of London, which created this IMT, the International Military Tribunal here. So he wouldn't be a prosecutor. He realized that he was actually an alternate here. And that's where we have the very delicate episode. He mentioned this in his journal here. You know, Donnedieu de Vabres, and that was a discussion we had there, is attacked in a journal called Le Populaire. It's the only newspaper that said that he knew Frank in international congresses. And Henri de Donnedieu mentioned this in the plane because it was published the same moment in the plane. He said, Donnedieu de Vabres several times went to Nazi congresses, and he had dinner with Frank here, a situation that actually bothers him here. But at the same time, in his book, Robert Falco just stated the scrupulous consciousness of his colleague throughout the trial. That's all he said about the scrupulous straightness of his colleague. And I'll rapidly finish now. There were a lot of things that happened during the trial, but all that, it means that in the non-public aspects, which we find out in his journal, since he came back first, he enters obviously the room always first here, which is very important, and he's the one who found a compromise following the principles of Donnedieu in terms of this conspiracy, and that's enabled to move forward and to be able to come up with a relatively positive outcome. Number two, to show the difference between the Anglo-Saxon common law approach and then the opinion of a dissident or not, and it's a compromise that was actually found. When in the end we actually explain that the two Russian judges don't actually agree with part the three people that were going to be listed Van Papen, Steeds and Up, and that was to avoid a dissident opinion, because for the French, you're not allowed to have a dissident opinion here. Descending, the difference in terms of the status of the judges. The Americans, they got all the means, resources, where they go back by plane here, whereas the French, they go back by train. You will actually see that they are not Judge Donnedieu de Vabres, they're not at all recognised. They'll just receive some medals here, but there's no recognition whatsoever. However, this network of magistrates will be extremely important after Maurice Roland. There will be an association of existing magistrates, and nearly all the magistrates belonged to Bost and Dubenet, and they will play an essential role. Michel Mathieu mentioned it this morning during the presentation, and during the law that goes back to 1984, crimes against humanity. Those magistrates played an essential role in the French discussions afterwards. Now, after Nuremberg, Robert Falco actually didn't say that much anymore. He stayed in contact with Birket, with whom he remained friends. Why? Because he was invited to Goering to different conferences. Both of them loved poetry here. And the evening after listening to atrocities, they would talk about poetry in French and English here. Now, a question, an issue which isn't regarding the Shoah. There was a very clear opinion at the beginning of the 50s when the issue was to actually come up with a memorial in terms of for the Jews. Robert Falco belonged to those who consider, quoting him, the Jews don't, in their books, they don't want a monument. Why not have a monument for those French who they defended actually the Jews? Because otherwise, if we have a monument for the Jews, will be like supporting what Hitler did, which was to put the Jewish people aside here. And this is my conclusion here. At the court, higher court, he got his activity back, and he was appointed probably because he loves the literature. He became the reporter of this decree to revise Charles Baudelaire's condemnation in 1875. What we never mentioned. He came up with an amazing report, absolutely beautiful. He had this general prosecutor who had a very liberal position as well here. But I was knew that particular prosecutor. Where did I find him? For those who remember Section Spéciale Castagrover's film, it's the general prosecutor who chose those particular files of the Jews, communist Jews, and who had been persecuted, to have them condemned to death by what's called a special section. And since then, he was a resistant as of the end of 1944. He wasn't actually bothered at all here, and he was never considered as being a collaborator here. And it's quite. And then in conclusion, he asked his colleagues to really do something about the mistake made towards Baudelaire. I mean, over time we can see the true face of things here, and really make sure that the flowers of Baudelaire are paid a tribute to here. And this is really
better you than me. So it is my privilege to make the mass talk. Like Jean-Paul Jean, I'm the member of the scientific committee here at ISIeux, and I'm a professor emeritus of a professor that's emeritus. That just means, well, I haven't been forgotten yet. I'm retired, but I haven't been forgotten. Normally, I was going to be accompanied by Laurence Le, but in the end, it's just me who's presenting to you today. So we're going to talk about Henri Donnedieu de Vabres. The Judge and Professor is a work that I published recently with Laurence Le. So as a professor, he taught at the Law School of Paris and of penal law, not international law, but he was very much interested in international law. Also a professor who was very much attached to the great principles, strict interpretation of legality, non-retroactivity, individual responsibility, the secret of deliberations. These are absolutely hard principles for him. He was also very so he was very classic about those principles, but he could be very open in many other respects. Open to the idea of criminal policy. In 1938, and it was republished in 2000, talking about criminal states, and he was talking particularly about Germany and the Soviet Union. Also very open to comparative law. So comparing the law systems of different countries. Daniel Vabres co-directed a review of comparative law to which Donnedieu de Vabres participated. And he traveled a great deal as well. I'll say more about that. And very much interested in international criminal law. Since the 1920s already, in his works, he was known in France as perhaps the leading, if not the only, international penal specialist. He also spoke German, which was another reason why he participated in the Nuremberg trials. So as a judge, he was on the IMT, International Military Tribunal, and so I'll say more about that. So I mentioned Philippe Sands earlier because in the history of Donnedieu de Vabres, there's a before and an after of 2017. I can tell you what we knew before 2017, just what we saw or heard, and that he was an old man, an eminently respectable old man, a very austere, not very wordy. Let me read something that was said about him. So Falco and Faure and others said this about him. He's very silent, austere Protestant, deep in his books and his notes, and uncomfortable in many social activities. Another person said that he is something of an allegory of justice. And with his wild hair and a large forehead, he seemed to embody a certain notion of justice as if it were a Gregorian chant. And one more comment on him from an American prosecutor about both French judges. In fact, he said, two curious little men. Falco seems insignificant, and de Vabres seemed remarkable. because of his very large mustache. So austere, rather silent, but perfectly respectable. One of the rare academics, in fact. So he was amongst the few who actually taught law. They often called him Mr. Professor, dear Professor. And so he was perhaps the only one who had this higher perspective coming from teaching law. He was a brave man. He led really 2 battles. And I'm not talking about what everyone mentions. So he had wanted that the executions of the military men be done by a firing squad, but he didn't obtain that, and they were hanged. So that was a losing battle. But during the month of the deliberations, he criticized very heatedly the notion of conspiracy as it had been introduced in the Rome Statutes and as the Anglo-Saxons wanted to apply it. Because for him the non-retroactivity was a principle to which he adhered. And, well, he lost that battle as well. So that went forward in spite of his protestations. But there was another battle that happened from the very beginning of his arrival at Nuremberg. And he had spoken with the prosecutors about this. He contested this notion of crimes against humanity as it was conceived at the time, because it would have applied to the Germans before the war for crimes against other Germans. So, you know, with war crimes, they could be judged. But here we were talking about new types of charges. And Donnedieu de Vabres won on this terrain because the trial did not condemn the crimes of Germans against Germans before the war. He's well known for his publications. He wrote a book about the IMT, which is a reference in the matter. He also wrote about genocide and participated in the drafting of the convention. So that was what we knew of him, according to research up to 2017. But then, that year, Philippe Assan's book is published in French. An impressive and interesting book, as is the author, as you noted this morning. But it's also a book that draws a portrait that is not very flattering of Donnedieu de Vabres. That's putting it kindly. In fact, particularly if we look at page 370. And I quote from the book: the newspaper Populaire had published an article saying a Nazi judge goes to the Nuremberg trials. So, calling Donnedieu de Vabres a Nazi, well, the family was horrified to see that. The public, all of the specialists are startled to see that. And the only other person who knew Donnedieu de Vabres, and this was Jean Danier, who well knew Donnedieu de Vabres, absolutely startled by this article in the newspaper. And so at the time, when Laurence Le Thiomier and I were working on this, we thought, well, we must absolutely continue our work on Donnedieu de Vabres to look at this more closely. So Donnedieu de Vabres, a Nazi, his son died as a resistance fighter. His son worked for de Gaulle. And Donnedieu de Vabres was chosen by the Secretary General to go to Nuremberg. And he is considered a very rigorous. Jacques Bernard Herzog, another Nuremberg magistrate, praised Donnedieu de Vabres for his professionalism and rigor, and often praised Donnedieu de Vabres. In 1942, he had refused to publish an article in the Law Review because it would have required him to seek authorization from the Vichy government, and he didn't want to do that. So let me get straight to my essential points. So Philippe Sand's position is based on three facts that cannot be contested. First of all, we know that Donnedieu had never hidden the fact. He had said it to Falco and to others that in 1935 he went to Germany to an academic conference organized by Hans Frank, who was a legal specialist who ran a learned society on law. And he had dined with Mr. Frank, who 10 years later was judged and convicted and sentenced to death at Nuremberg. So having had dinner with Frank is, of course, problematic. Donnedieu de Vabres even said to Falco that he was very embarrassed by this. Retrospectively, given what we know about the European Court of Rights and the independence of the judiciary and the independence of judges, this would appear untenable, and Donnedieu de Vabres should have withdrawn. But I have several arguments with this. First of all, if we look at the various publications based on archives, what we can believe is that we can show that when Donnedieu de Vabres accepted to be a judge at Nuremberg, he didn't know yet the list of the accused, in fact. So perhaps should he have withdrawn once he learned of the list, seeing that Franck was on the list? But given how quickly things were going, it seems that he would have chosen not to withdraw, given the urgency. also, as I said, he was a well-known academic, and, well, the conference speakers are always invited by the organizers. I'm sure that, I could tell you that I myself, out of politeness, I will accept, even if I'm not particularly thrilled by the idea. And we also know that Donnedieu de Vabres and Franck, in fact, disagreed a great deal. And in fact, Franck was very hostile to Donnedieu de Vabres on many points. But we do know that they had dinner together, and then he was the judge before Franck in 1945. But without any other form of proof does not make him a Nazi, to my knowledge. And so let's come to the second known fact, is this press article. Okay, and Falco says that, and Philippe Sanz mentions this, but neither know the date, knew the content of the article, but we managed to get our hands on it thanks to Stéphanie Boussard, working at the National Library of France. And here is the text that was published on Sunday, 7th of October, 1945. A pro-Nazi will judge war criminals. The French government has just appointed as a judge for the trial of the war criminals Mr. Henry Donnedieu de Vabres. If no other is more qualified than him, because even before the war, he had participated in the works of the German Law Academy and has published works in their academy. However, the trial will be conducted by civilized countries under international auspices. So how, therefore, can we appoint a man who has sympathized with the Nazis? He must have known them quite well, since he is a professor of criminal law. So this is an incredible turning of the coats, or of the robes in this case, appears a provocation. Of course, professors must be able to express themselves freely, but it is nonetheless a scandal that he is still on the faculty of law, but to appoint him to the trials is even more unacceptable. So the end of that article is crazy in many ways. So we've conducted a lot of research around some of the law professors who had actually collaborated with the Vichy, and none of them accused Donnedieu de Vabres. And one researcher was only studying professors of criminal law, and yet he makes no mention of Donnedieu de Vabres. So that aside, well, what have we heard here in this article other than this dinner that Donnedieu de Vabres had dinner with Franck? And Philippe Sanz says that the Soviets had tried to oppose his appointment, but we don't know exactly how that would have been possible for them to oppose that. That doesn't seem possible, really. How could the Soviets tell the French Ministry of Justice what to do? But we have a different view on this. The Soviets would have given the following argument, and that would have been what was said in the article. It's the crisis of modern criminal law. Looking at Germany and the Soviet Union, and both are very hotly criticized. And so Donnedieu de Vabres, it was even more severe, more critical of the Soviet Union than of Germany. So was that made the Soviets want to try to challenge his appointment? We don't have any other evidence of this. And then, third fact. During the deliberations, Donnedieu de Vabres is the only one who voted against the death sentence against Frank. And so this is a touchy moment, of course, because the deliberations are secret. But there were some leaks that allow us to understand a bit how things happened. To my knowledge, there were only two potential there are only two sources. One is the personal notes of the Judge Donnedieu, but we don't know if he was intending to make them public or not at the time. And the second source is a work by Falco. So Donnedieu de Vabres never expressed himself, never said anything about those deliberations. So we have his notebooks where he took notes during the hearings. They haven't been fully analyzed. Perhaps we will be able to find out more about what happens during the deliberations. But his will was, he was against the idea of publishing them. But from what we've read elsewhere, what we note is that, first of all, the French judge was the least severe of all of the judges. In fact, others wanted just about everybody to be executed. Okay, the English, the British, and the Americans were changed positions occasionally, but what we saw was that Donnedieu de Vabres' position as concerns Frank Frank was not the only one where he protested against a death sentence. And one of his main concerns, in fact, was to ensure fairness in the sentencing. Of course, based on what was heard during the hearings, but also given things that were said during the deliberations, to try to be sure that after the work was done, that there would be a fairness in the outcomes in the sentencing. So, those three facts, which I have just presented to you, we believe that this is means that we must be very careful in the way we evaluate Donnedieu de Vabres' position, and we must be very prudent about that. And with my colleague, Laurence Le Turme, we have looked at all of Donnedieu de Vabres' works and statements and decisions before the war, and how he worked after the war as well. And so, as you can imagine, this represented a lot of work. But at the end, we were thinking, what are we looking for? to know if he was more or less a little collaborate.
Was he actually anti-Semitic here? Because that's what the article was stating, but the very proof that he wasn't anti-Semitic, we had it from the very beginning. Let me provide you that proof. It's a document in which the Ministry of Justice was informing the Ministry of Foreign Affairs about the choice that had been made in terms of the French judges. And the Minister of Justice, so we talk in Tergan's cabinet, and all the residents wrote to the Ministry of French Affairs. So we chose Donnedieu de Vabres, considering he's a specialist of international criminal law. He took a position during the occupation against Vichy legislation, and he speaks German fluently. That's what the people said who knew him and who chose him. Sorry, I went over time. It is time to conclude. We are already running a bit late. I really wanted to thank all the speakers for the quality of their papers, of their work, and things which we found out, known things, unknown things, the quality of the initial debates and discussions. I'd like to thank you all for being with us to the very end, and for being so attentive here. I really would like to say that for the Maison des Yeux Center, this theme, this link to international justice is crucial. It clearly opens up a lot of perspectives and a definite outlook in terms of our educational approach, in terms of what we can convey about ISIeux. It's crucial for us that the confidence that the families have demonstrated toward us by the family Dubin and the family Donnedieu de Vabres. Thank you very much. I'd like to thank the families for their presence and have a safe trip back home. Thank you. Well, we're not running that late.
What?
We're not really running that late. It's just it's going to be a long way back.
I can hardly set my foot down now.
Yeah.
It was fine until I get